Three Meem Foundation, we've had the blessings of being an organization who have been introducing so many different types of webinars. We want to continue this today by introducing a very practical and important topic of Islamic wills. So we're really hoping that we can introduce a greater awareness of why we want to write wills and how to go about doing this. And to really understand the significance of why we want to write wills from an Islamic perspective, there's a quote from Sahih Bukhari as well. It is a duty of a Muslim who has anything to bequeath, not to let 2 nights pass without writing a will about it. So that's the context of our webinar today. And let me introduce you to our speaker today. His name is Ali Shah. He has a very decorated career. He's a gold medalist and award-winning personality. He's gained a master's at the University of Bradford, and then he's gone on to do an MBA. His areas of speciality are property law and wills and probate. He's a licensed probate practitioner and a licensed conveyancer. We will pass this on to our brother Ali Shah in a second. And in the meantime, what we'd like to do is leave any of the questions and answers possibly to the end. And in the meantime, if you would like to put your questions into the chat section, then we could read those out at the end as well for Ali Shah. So Ali Shah, really over to you.
Right, thank you, Mohammed. As Mohammed just introduced me, my name is Ali Shah, and I am a licensed conveyancer and probate practitioner. I practice in Manchester. Obviously, today we don't want to talk about our practice and things like that. It's more about it is an introductory sort of seminar providing some basic information about UK will and inheritance law, and also just to provide you some awareness of how you can make a will in an Islamic way. They are also called Sharia-compliant wills, Islamic wills. There are many names, which have been given to wills, but actually under UK jurisdiction, under UK law, they're just like a will, However, the way you're going to be distributing your estate in your will, if it is made according to the Islamic inheritance law, obviously that's going to be beneficial. If not, if a person leaves this world without a will and they were resident of the UK, they will be considered as in state, and their estate will be distributed, and their estate will be distributed according to the intestacy rules, which means that some of the so which means that your estate can go will be distributed according to the law of the land, not the Islamic law, and you can end up leaving number one, a big inheritance tax bill for your family. Secondly, you can also, this will also leave you with leaving stuff for in a way that you normally don't want to. So if I'll be talking in detail about what happens when a person dies, and if they've got a will, what's the procedure, and if they don't, how the estate is distributed. But it is certainly not distributed according to the Sharia law, which is something you may worth considering, and that could be a major reason why every Muslim living in the UK or even abroad should be leaving a will. Before starting the actual presentation, I would like to obviously you can see it on the screen as well, but please note that this presentation or any discussion during today's session is only for information purposes. No part of this presentation or discussion constitutes any legal or tax advice. It's just because uh, we, once you go to a licensed practitioner, they will be the legal person and you should be listening to them. Today, we are just going to discuss things according to the UK law and the Islamic inheritance law. And it's more like discussion where I can learn from yourselves and you can learn something from me. Right. In today's session, obviously, I usually run these sessions, in face-to-face settings. So and I prefer that because obviously they're more interactive and you don't have to just listen to somebody. So, but unfortunately, due to COVID-19, we can't do a face-to-face session. So we have to take Zoom. One disadvantage of Zoom or any other online platform is that we can't interact as frequently as we want during such discussions. So as Mohammed said, we will leave the questions and answer session towards the end. However, I hope you can make some notes, during the session. And if you got like any questions, you can just ask them towards the end or towards the end of the session, after the session, you can take our contact details from the event organizers. And if there's some more information that you require or any legal advice, then you can come back to us. Right. Today, we're just going to be covering, as you can see on the screen, what a will is. And obviously, everybody knows what a will is, but we will just try to go into some more details by presenting you that what constitutes a valid will. Then we'll be talking about UK inheritance law, intestacy law, and and again, because United Kingdom, it is divided into 4 countries, and England and Wales, which is our jurisdiction, have got certain different laws as compared to Scotland and Ireland. So if you're domiciled in England and Wales, obviously your inheritance distribution is going to be according to England and Wales. Obviously, there are certain differences between for the people living in Scotland. So if any brother or sister listening to today's session, are domiciled in Scotland, please look into your local jurisdictions and the regulations. Then we'll also be looking into, which is the core theme of today's session, which is going to be the Islamic or Sharia law. What are the benefits of Sharia-compliant will? Then we'll also be touching on inheritance tax, charitable legacies, and then we will also talk about, appointment of executors and appointment of guardians for any minors will. Right. Why I'm trying to define a will over here is because there is some confusion over oral wills, or when a person is dying and if he's making a deathbed wish, at times they are considered under the law. You have to prove it in the court. But however, the best way or to leave a will is it should be in a documentary form. And a will is a document, it's a legal document that a person who is called testator wishes how his estate, personal or real estate, so it could include anything that he owes, money, land, any personal items, anything, any businesses, everything is going to be good. So how they want it to be distributed after their death. And the most important thing that you can do in your will is you can nominate an executor. We'll be talking about executor in a second, but that is a person that you trust who is going to distribute your will according to your wishes. Now, many times you may have family members, but you don't. You may have your own children, your wife, your brother, your sister. However, at the time of your death, probably they're not in the best of their mental state because of the loss, or probably they're not very good at certain tasks, because it is a duty. You have to, like collect all the assets of the deceased and distribute them according to the will. And it may also involve, taking grants from the court and things like that. And not everybody is willing to do all those things. So nominating an executor in your will is very important. And obviously, when you're nominating somebody, you have to take their consent and uh, check with them if they are up to this duty. Obviously, we know that it is also known as wasiya or wasiyat, in Islamic jurisdiction. Now, key components, obviously, in your will, that is your personal document, that is your document. You can write anything you want to, you can make any sort of wishes you want to. However, the key elements, of every will should be, first of all, how the deceased funeral and burial wishes, how you want to be buried, and what sort of funeral you want. Obviously, all the Islamic brothers and sisters, would like to have a burial. But if you belong to a certain type of sect, Shia, Sunni, or if you follow a specific school of thought, you can make those wishes in your will. It is going to be helpful for your executors to know if you already have purchased a plot in please, you can also you can mention that as well. I will request if all the uh, right. Then you can also, as I said, you can nominate your executor who will be in charge of administering your estate and sorting out things on your behalf. Once you're not here. And as I said, that could be a very simple task, or it could be a very big task. Now, the beneficiaries of the will, a technical point here, it can be the executors as well. So, for example, if you got a son he's one of your beneficiaries in the will, he can also be the executor. Obviously, we'll be talking about the witnesses in a second. They can't be the witness. Wow.
Sorry to interrupt. Can I request all participants to mute at every point of your participation in the meeting, please? Thanks.
Then the appointment of guardians, it is also something that you can address in your will. Then we talk about in your will any gifts or legacies you want to leave in the will, and we're going to be talking about how to do them in the best way, in the Islamic way, in a second. But this is something you can be very specific, like you can mention, I want to leave that particular house, or that particular car, or that particular item of jewelry to my daughter or to my son, or to a friend. So you can be as specific as if you want to, or you can leave like a generic will and divide shares of your estates. For example, you can say 10% goes to my son, and we'll be talking about it in a second. But as I said, you can be as specific as you want to when you are explaining or defining the gifts, or you can be very generic. And finally, you can also include any charitable donations you want to make in your will. Now, these charitable donations can be made to charities, or they can be made to individuals as well. Obviously, when we are under the UK law, obviously, if we want to leave anything as a gift, that will be covered under the legacies and the gifts. However, under the Islamic law, obviously, you can leave up to 1/3 of your state to the people or to the beneficiaries who are not your normal receivers of your state. We're going to be talking about it on the next slide. But what I'm trying to say over here is, that charitable donations can be made to individuals, or they can be made to charities. And if they are made to any UK registered charities, or if they are or to sports clubs, or there are certain other exemptions as well, they may also help you in your inheritance tax bill. That's something we'll be addressing in the next slide. Now, we've come across a lot of wills, during our practice, which are not valid. And that's why, you have to, when you're writing a will, you need to actually research on the area a bit, and make a will which is valid, because probably you may have made a will and it's there, and you're happy that you've got a will, but it may not be valid. And when it's the time that the will is executed, at that point, it may be considered as void. And if it is void, then your state is going to be distributed not according to your wishes, but according to the law of land. So what makes a will valid? First of all, it should be in writing and signed by the testator, or somebody in the presence of the testator by his direction. So for example, if somebody is not well, if somebody cannot sign his name, or for any other reason, they are not in a capacity to sign their own will, they can authorize a person to sign the will on their behalf. Obviously, it would be made clear on the will that the person is signing. So the language, of the executorship clauses are going to be slightly different if someone else is signing on your behalf. However, the wills are considered valid if they are signed by someone else in the presence of the person who is making the will on their directions. Obviously, a formal protocol is followed in order to execute a will on somebody's behalf. However, it is possible. Secondly, to make a will valid, it should appear that the testator intended by his signature to give effect of the will from on the date of the making of that will. So when you are writing your will, make sure that you use and you make an explicit statement that I want this will to be effective from that particular from today onwards, and this is my last will, and I revoke all my previous wills, if you have made any. Now the signature is made, and this is the most important bit, which usually is not done properly, and which leads a will to being invalid. uh, the signatures is made or acknowledged by a testator in the presence of two witnesses present at the same time. So when you're executing the will, you should have two witnesses, and please make sure that these two witnesses should not be the beneficiaries of your will. So if you're leaving anything to your children, your family members, they cannot be the witness. So anybody who is getting any gain from that will, they cannot be the witness. So both witnesses should be witnessing the person signing, and when the witnesses are signing, making their signatures, the person who has made the will should be present there as well. So all these three persons should be in the same, ideally in the same room. But obviously I'll be talking about the COVID-19 and the new regulations on signatures and Zoom signatures and things in a second. However, the essence of the law is, that everybody should be present in the same room. The witnesses can see the testator signing it, and the testator can see each witness signing the will. Now, the government has made certain flexibility this year because of the COVID-19, and the witnesses may not be present in the same room, but they can overlook in from a window. Or for example, a person is sitting in the car and the witnesses are standing outside, and they also allow online electronic signatures as well. So for example, you can see a person on the Zoom or any other electronic portal signing their will, and then the other with the two witnesses, can be on the camera. They can see it at the same time, or they can do it individually. Obviously, there is a formal protocol which should be adopted in order to make the will valid. And I would advise, if somebody is considering using online or remote signatures, they should seek a practitioner's advice in this regard. Otherwise, you may be making the will, however, it's not going to be valid. So these are a few points, they are very generic. They applies to all sorts of will, whether they're Sharia compliant or they are any will, which are made in the UK. They should be considered, according to these rules. Now, UK inheritance law, it applies to all official residents, whether in nationals or from overseas, on all their worldwide movable assets. Now, if deceased is not resident who owns property in the UK, British inheritance law and consequently inheritance tax in the UK will also apply to some of their estates. So obviously, inheritance tax has got their own thresholds, which needs to be considering. You may end up with zero inheritance tax bill, or you can have like a higher inheritance tax bill, depending on where your assets are and how much the assets have been valued at time. Now, inheritance law in the UK vary across different parts of the country. In England and Wales, as I said, there is no forced heirship, and people are free to leave their property to whomever they want to. However, in Scotland, surviving spouses and children have a statutory claim to parts of the state. So as I mentioned earlier, if you are part of those jurisdictions, please look into your specific regulations and make sure that your will and yourself, is adhering to them. If a British resident dies without leaving a will, intestacy law determines how their estate is distributed and what inheritance tax is to be paid. Again, it is different in England and Wales and in Scotland, so it's better to look into the inheritance tax rate, and the thresholds in different parts of the country. Now, this is like a very sort of information-rich sort of slide. I'll try to make it simple as much as I can. So this is kind of a grid which provides you like different situations and what sort of regulations or rules would be applied to you. So if there is a surviving spouse of the deceased, it could be a spouse or a civil partner. I'll be talking about it probably in a later part of the presentation as well. But to get qualified as a spouse, you need to be married to the person, either in a religious ceremony or in a civil partnership, or like in a civil ceremony. Any living partners, like any people who are not married or civil partners, do not automatically get the right to inherit the deceased state, even if they don't have any children or any other survivors. So it is important that if somebody is living in a situation where they are not married, they should actually leave a will nominating their partner. As of February 2020, the spouse partner or the partner receives the first. So, for example, if you left a state and you didn't, so if a person dies and they did not have a will, and now they are considered as intestate, and which means that their estate is going to be distributed according to the intestacy rule. So, from their estate, the spouse or the civil partner will get 270K, and then the rest of the estate is going to be divided into two parts. So the first part will again go to the spouse. So the spouse will get 270K and £270,000, and the half of the remainder of the estate. Now the other part of the remainder half would be divided equally in any children. And so, for example, if you got one daughter and one son, so it would be divided equally, not as per the Islamic way, where a daughter gets half and the son gets double of it. The share of any minor children is held in a trust until they reach the age of 18. So if you do not, if you die without a will, obviously you've not nominated any guardian. In that situation, it's the court who is going to nominate the guardians, and it could be a person that you don't want to be the guardian of your children. So it is another point, that's worth considering. If any children are deceased, their share goes. So, for example, amongst your children, if anyone predeceased you, like if they died within your lifetime, or if they died before or after you, before the actual distribution of the state, their share is going to go into go to their children, so your grandchildren, and if more than one in equal parts. So again, if there's a granddaughter and a grandson, they will both get the same share. The spouse or civil partner inherits even though the couple may have informally separated and they have not legally divorced, still they will get this. So for example, if a person has been separated from their spouse, but they were not divorced, the spouse will still get their share. So people who have who are separated but not divorced, or they've not done the legal procedure, or they're in the process of it, that would be another point to be considered, that your spouse will still get their share unless there is a formal divorce filed in the court. Now, in the situations where there is a surviving spouse but no children, so if a person dies and there is no spouse, there are no children, in that situation, again, the spouse is, and there was no will, so the spouse will get the first 270K, and the remainder will be split half between the spouse partner and half to the surviving parents of the deceased. Now, under Islamic law, the parents of the mother and the father, if living at the time of the death of the deceased, they get they are one of the mandatory parties, to get under Islamic law, to get something out of the deceased state. Under English law, for example, or the law of the country, they only get the share if you don't have any children. Now, in these situations, for example, if you are supporting your parents during your lifetime, probably their survival would be harder after your death. Or if you're surviving any other, relatives or friends, or any, as I said, people who are not your friends and family, but general public, that you were supporting during your lifetime, any charities, they will not get an automatic right on your state. So again, another point to be considered, when we are advocating to have a will. Now, if there is no surviving spouse or partner, the whole state is distributed between the children or the grandchildren. If there are no children or grandchildren, the state passes to the following groups in descending order. So first of all, if the parents are alive, it will go to the parents. If not, then it will go to any siblings. If there are no siblings, then it will go to nephews and nieces. If no nephews and nieces, then they will look if you had any half siblings or their children. If not, then it would be your grandparents, your uncles and aunts, and if they're not there, any cousins, and then half brothers and half sisters of parents, So it will go, as I said, it is like in a descending order. So each category will be having a preference, in the list. So each category which is prior to the other category has got a preference. So if you have parents, then obviously not going to siblings. So again, if you want to research or go, if you want to learn more about it, all the information is available on the Gov website. You can actually go over there and find out, who is going to benefit from your state if you die without a will. Now, under Islamic or Sharia or inheritance law, which is our key topic for today, but I just wanted to give you some background of the English law first. Islamic law sets out strict and rigid inheritance rules that determine how Muslim states to be divided between his or her heirs at the time of death. Inheritance is considered as an integral part of Sharia law, and there are very clear-cut rules in Quran, and then in also in Hadith and in Fiqh. It has been explained in a lot of detail. Another point that I found during my studies and my research is that there is some difference on some minor issues, but it could be minor for me, but it could be very vital for a different person. So when we talk about different school of thoughts and different sects of Islam, Shia and Sunni there. So overall ruling is kind of standard, but there are certain differences between different sects when it comes down to who inherits what, in your will. For example, there is a difference between Shia and Sunni inheritance tax rulings, on unborn child. So for example, if a person dies and the wife was pregnant and a baby has born later, there is a difference between there in Shia and Sunni school of thoughts. Then about leaving your inheritance to your grandchildren. So there is some difference between Shia and Sunni school of thoughts, in terms of if the child predeceased the parents, or if he was dead in the lifetime of the parents, whether the grandchildren should get it or not. So it's very important that whatever school of thought you follow or sect you belong to, go research in your own area and try to have an understanding of what are the best options for you, and they should be reflected in your will. Now, under Islamic law, the freedom of leaving your state, it is limited. So in a way, Islamic law binds every Muslim to leave a set part of their state to their family, the people that we'll be talking about on the next point. So there are certain relations which are your wife or husband, son or daughter, and mother or father, which are like 6 categories, that Islam defines. They should be, they must receive something from your state, and it should be the 2/3 of your state. So 2/3 of your state must go to your descendants or your survivors from these categories. And you only have freedom over 1/3 of your state, that you can leave to anybody or any charity. So in a way, the freedom to leave your will, under Islamic law, it is limited, because you cannot just leave all your state to a charity or to a particular son or to a particular member of your family or a friend. You only have the freedom to make such wishes on over 1/3 of your state. The remaining 2/3 of your state should be divided amongst the people defined by Quran. Now, what happens is, that and that is divided after deduction of any debts that deceased had, or any taxes due by the local jurisdictions. Now, when a Muslim dies, there are 4 duties which must be performed, from his state. First thing is pay the funerals and any burial expenses. Then paying any debts of the deceased. Then the next goes into, you need to distribute any legacies, and that includes all the charitable legacies, or the gifts or the donations he made, to individuals or to organizations in his lifetime. But as I mentioned, it is only restricted to 1/3 of the state. The remainder of the state, which should be divided according to the Sharia law. So the 4th step would be divide the remainder to the relatives of the deceased according to the law, Sharia law. As stated earlier, the 2/3 of the deceased estate that is subject to a Sharia inheritance rules will differ depending on Islamic sect the deceased belong to. So it is worth looking into how you, what your usual practices are and follow them. Most commonly, as I said, it is distributed in accordance to hierarchy of 3 classes. So the 3 classes, the first one are Quranic heirs or sharers. Second one are your residuary heirs, and we'll be talking about the residuary heirs on the next slide. The first class includes, as I already mentioned, your 6 categories of people: your husband or wife, son or daughter, father and mother. So these people must get, if any of these categories have survived the deceased, they should get a share out of the deceased state. The first group are entitled to specific shares, but they cannot all inherit at the same time, and some may exclude others, because and again it is in a way a hierarchical system. A husband is entitled to half of his deceased wife's estate if she has no children. If she has children, he is entitled to a quarter of the share, and the remaining is going to be divided amongst the children. A wife is entitled to a quarter share of the deceased husband's estate if she has no children, but if she has children, she is entitled to 1/8, which is like the most commonly understanding. Sons usually inherit twice as much as their sisters when one of their parent dies. In the absence of children, the grandchildren or remoter issue would inherit, although the daughter's children are unlikely to inherit if the daughter has died. But as I said, please look into your own individual school of thought and make sure that when you're making will, you don't exclude people that you would have otherwise included. The second group of people includes the grandparents and siblings. In the absence of siblings, nephews and nieces inherited. So it's very much the similar way as the English inheritance, but again, there are certain categories which are not included in there. The third group includes parental and maternal aunts and uncles and their descendants. So each category, as I mentioned, would be getting an hierarchy. So if there is nobody in the first group, then you move on to the second group, and then if there's nobody in the second group, then you move on to the third group. Specific rules govern half brothers and sisters and step parents. Half brothers and sisters only inherit if there is no full brother or sister alive at the time of the death. Lastly, adopted children are not considered as the couple's own, and therefore they are not within the primary heirs, but the deceased can leave them out of the 1/3, that he has his own authority on to that to the adopted children. You can also give your adopted children any lifetime gifts. Now, with lifetime gifts, if there are any gifts which are made within the last 7 years of the deceased death, they will still be considered as a part of state only for the for the inheritance tax purposes. So that's something you also need to consider that, and we'll be talking about inheritance tax in a second. Now, what are the benefits of having a Sharia compliant will? Under Sharia compliant wills, Muslims can also, number one, assign executors to handle their estate after once they're passed. So it's very similar to the English wills, or again, all wills are English. Just to differentiation, I mention it. You can appoint guardians to your children. You can make provisions for any younger children and how they and to invest in their to invest their inheritance, or the maintenance of their education. And this can be done by investing in a Sharia compliant trust, So for example, if you don't want the children's state or the minor state, to gain benefit of interest-based products and things, then you can make those arrangements, that what that trust can do and what they cannot do. So you can also define things like that in your will. Then you can also divide 2/3 of the estate according to the Sharia law and not according to the law of land, and stipulate who would they likely to like up to leave the remaining 1/3 of your estate. You can agree what charities, if you want to, if you wish to leave to any charities, you can mention the names of those charities in your will, and most importantly, you can specify any funeral requirements. As I mentioned earlier, it could be we had a situation very recently where there was a dispute at the time of death because the deceased did not leave any will, but he made a wish to one of his friends that I want to be buried according to Shia customs. However, the whole family was Sunni, and then there was like a dispute or at the time of death. And on the funeral day, which is something, which is very unfortunate and it should not happen. So to avoid certain circumstances, and to give proper guidance to your children and to your executors, it is very important that you leave specific, if you have any specific requirement, just please mention it over there. Now, UK inheritance tax. It is a very, I would say, interesting topic, controversial as well, because it's one of the highest tax, 40% of the deceased state, over the threshold. However, there are ways, by doing proper state planning, that you can avoid some bits of your inheritance tax. Now, inheritance tax is a tax on the state, which includes property, money, or any possessions of someone who's died. There is normally no inheritance tax payable if either the value of your estate is below the threshold, which is currently £325,000. Or if you leave everything above your £325,000 threshold to your spouse, civil partner, or to a charity, or to a community amateur sports club. So if you're leaving everything to your spouse, then there is no inheritance tax payable. However, this is, as we already discussed, this is not according to Sharia. You cannot just leave everything to the spouse. So, and this is another observation of mine, that a lot of Muslim brothers and sisters, when they come down to us and instruct us to write their will, usually they just ask us to make a will that everything goes to their spouse, and when the spouse dies, it goes to the children according to like in equal shares. Obviously, we are not in any position to advise them on what they want to leave in their will and to whom. However, in my observation, it is certainly not the right distribution, not according to the Sharia. But again, as I said, we are there to help them document their wishes the way they want to. But the most common, as I said, reason why they do it, number one, is obviously this inheritance tax bill, because they don't want their spouses to pay the inheritance tax. And secondly, because of the way this is the UK society is, if the person dies, obviously the spouse will be highly, and if the spouse was highly dependent on the deceased, it's hard for them to actually, find ways. So also so it's preferable that everything goes to the wife, and then after that, it goes to the children. But as I said, if you plan your state properly, and if you look into your affairs, well before you anticipate, I think it's going to be helpful for you. And so you can not only leave because you remember you have that 1/3 of your estate, that you can leave to anybody, and that could also include your wife, because if you got any apprehension. So, as I said, one needs to do proper estate planning, once before making that will. Now, if you give away your home to your children, including adopted, foster, or stepchildren or grandchildren, the threshold will be increased to £500,000. So it's not if you're leaving your house, where you were living, to your children or grandchildren, the threshold will increase from 325 to £500,000. Now, if you were married on civil partnership and your estate is worth less than your threshold, any unused threshold can be added to your partner threshold when you die. So, for example, if a husband dies and his estate was lower than the threshold, for example, his only estate was 100,000, so he had a £225,000 threshold left, which will be added at a, so when the wife dies, that could be added to the wife's threshold, which will allow them to so the heirs of or the beneficiaries of the wives will will get the benefit of this added threshold. So 325 from their mom and that 225 from their dad, so that would be included. So this is like this band, the threshold can be transferred between the spouses if they are in if they are married or in civil partnership. The inheritance tax, as I said, the standard rate is £40,000. Sorry, 40%. If it is only charged on the part of your estate which is above the threshold. So, for example, if you left a total estate of £400,000, 325 is your threshold. So you're only supposed to pay the tax over the estate which is above the threshold, which is 75,000. So 40% of 75,000 would be your inheritance, like in a very simple way. However, if the estate, if you leave, your inheritance tax will be reduced to 36% from 40%. On some assets, if you leave 10% or more of your net value of the estate to a charity in your will. So if you leave anything which is 10%, net value of the state of the net value of the state to a charity in your will, that will leave you with a lower inheritance tax bill. Now, I think I've got like a quick illustration towards the end, where now leaving some funds to charities, not only helps you with your inheritance tax bill, but also it will help the charity as well. Now, I've got an illustration that we'll be talking about in a second. If you're leaving something to a charity, obviously your regular beneficiaries are going to be getting a lesser share of the estate. However, they're also saving on the inheritance tax. And if you do your math, and it is not a big loss, but it is a big gain to the charity. So please do consider, if your estate is over the threshold, do consider leaving, some charitable legacies to UK registered charities. Now, where death occurs after 5th of April 2012, and where 10% or more of the estate is left to a charity, the charitable gift is tax-free, and remainder of the estate attracts 10% discount, which is like 4% of the 40. So your inheritance tax would be 36% rather than 40%. And as I said, under Sharia law, you can leave 1/3 of your estate to charity, so which is going to be it works very well with Sharia law. So that's why if you want to, that's going to be an ideal situation. Now, just for an example, if a person dies and his net estate was £425,000, and if he left in his will, he left all to his partner, but they were they were not like married partner or any civil partnership. So what happened was, um, they still have to pay inheritance tax bill because she cannot automatically take it without. So first of all, they need to look into the threshold. So threshold is because it's not left to grandchildren or children, it is left to a partner, which means the threshold is not going to be £500,000. It's just going to be at a lower threshold, which is £325,000. So the net state, of the deceased would be £100,000 because his total state was 425 less the threshold. So net state was 100,000. So if we, and this £100,000 is taxable at 40%. However, if he leaves £10,000, which is 10% of this net value, to a charity in his will, his inheritance tax bill would be 36%, which is going to be £32,400. So in this first event where there was no legacy made, he was paying £40,000 tax, inheritance tax. If there was a legacy made to a charity, the inheritance tax would be reduced to £32,400. You will say it's not a huge difference. However, the actual beneficiary is receiving only £2,400 less, but the charity is gaining £10,000. So if you say it is not a big loss to the beneficiary, however, it's a big gain for the charity. So this was just one example. I don't know about your individual states and the value of your states, but if you have anything above the threshold, and if you are a supporter of certain charities, it is a good idea to leave something for your charities. Now, appointment of executors, I'll try to quickly go through these next few slides, so then we have some time for the questions and answer sessions. Executors are the person who are appointed by the testator to testator's will to administer the estate. As such, the authority to act derives from the will, and all the property left by the will becomes the property of the executor when the testator dies, and the executors are entitled to deal with it from that time and before any grant is issued. Obviously, when you're appointing somebody as an executor, they will be having all control of your property until the estate is distributed. So make sure that you appoint people who are trustworthy, people who are willing to take up this job, people who are who is fine, or who's in like who you believe will be objective, and not perform any biasness when it comes down to distributing your estate. A sole executor always have full authority to act when where a minority or lifetime interest arises. So you can leave people, more than one people as your executors as well. You can leave any number of executors if you want to. However, in terms of courts, when we apply for the grant of probate, it is only limited to, so only 4 executors can apply for grant of probate or letters of administration. So in that case, obviously that's going to be limited. So that's why you need to give a hierarchy. Now, if you believe that a single person should not make the sole decisions, you can actually appoint joint executors, and who can make decisions by mutual consent, or they can make joint decisions, or they can make like individual decisions. All those authorities, you can actually specify in your will, that which will guide your executors to deal with your state, according to your wishes. Now, appointment of guardians. Guardians may also be appointed for children who are under the 18, known as minors. If you fail to appoint any guardian, it's already said, for your child, and both you and the child's other parent dies, what will happen is the court will typically assign or appoint a guardian. And as I said, in that situation, the court will appoint a guardian who the court thinks is the best person, to deal in that capacity. However, it not be the person, you know, that you would have initially appointed. So it's worthwhile appointing the guardian. Now, who can be a guardian? A person who has a parental responsibility for a child can appoint a guardian for the child in their will. Parental responsibility means the rights and the duties that you should expect to be from a parent, in terms of like making decisions for a child. They may, for example, make decisions about the child's education, medical treatment, or where the child lives. A child's mother always have the parental responsibility for her children. So, for example, if a person is making a will, you know, and you are making and you're appointing a guardian, the mother would be having the first preference in terms of the guardian. Yes, if the mother also dies before the children reaches the age of 18, then you can nominate a person other than a mother, you know, to be the guardian. If a parent of the children were married when the child was born, they will both automatically have parental responsibilities. If parents were not married when the child was born, the mother automatically has a parental responsibility, but father may acquire it in number of circumstances. So that's something worth considering, you know. That was all about, you know, today's discussion. I would now pass it back to Mohammed, who can take your questions, and then we will discuss your questions individually. I know we are running over the time, but probably we can spare another 10 minutes on questions and answer sessions.
Okay, we have one question here. So the brother is asking, can will executors be outside UK, or should they be British nationals or based in UK only? Yeah, so I think the question is relating to whether they need to be UK residents, or can they be outside, from outside of the UK?
Well, my advice always to my clients is, you know, that if you have got assets that you're leaving in your will, you know, are from in the UK, probably it is best to appoint somebody who is a UK resident. However, under the law, there is no restriction. Anybody can be executor of your will, you know, whoever you wish to. So, but again, if they are overseas and if your assets are based in the UK, it may be harder for them to actually deal with your assets in full capacity and to distribute your will, distribute your estate. So it really depends on your individual circumstances. If most of your assets are overseas and you want to appoint somebody overseas, I think that will work for you. But if most of your assets are in the UK, it would be an ideal situation to make an executor who is resident, or at least he has got access to the UK, so he can come down here and deal with your estate.
Okay. Someone else has asked a question here, is how does pets affect a will?
Pets?
Yeah, it's a PETS. I'm not sure if that's an abbreviation for something.
Hi there. Sorry, I just would like to just elaborate on that. Potentially exempt transfer is what I meant is short for PETs. That's where you gift an asset before you die, and obviously there's lower tax burdens on individuals by giving away pets rather than leaving it an inheritance.
Yes, so you know, any legacies or gifts that you have made in your lifetime may be considered for your inheritance tax, depending on when they were made. So the IHT, the inheritance tax, you know, rules are that any legacies or gifts made during the lifetime within the last 7 years of the deceased death are considered or counted towards the inheritance tax. Now, there's a sliding scale of the tax. So the more remote the gift is, or the legacy was made, lesser is the tax. The more closer the legacy was made, the higher is the tax. However, yes, they do get counted for your inheritance tax. There are certain exemptions in terms of your gifts, but they are very minor. For example, gifts made on Christmas, like any cash, there's a limit of £300 on them as well, and then there is a limit if, for example, if one of your child is getting married, and if you want to give them something, in terms of gift, that is also restricted to £5,000. So you can't make like major legacies during your lifetime. If they were made 7 years prior to your death, yes, they are exempted.
Okay, there's another question here. If a child has learning difficulties, what's legal and Sharia law regarding inheritance of that child? Can siblings be made responsible for giving share or spending the share on that child from his inheritance share?
I think the ideal way is to form a trust for the person who cannot make his own decision. That's what I'll be thinking about. When we talk about children with learning difficulties, you can set up a trust, and the trustees so the siblings can be made trustees of the trust, so they can make those decisions on behalf of their brother or sister, or like any other relative or a guardian that you've appointed, can also be the trustees. Now, again, you can also take a grant of protection and things like that, for people with severe learning difficulties or disabilities. So that's something, probably you need to discuss with your practitioner, once, and they will guide you according to your individual circumstances. But yes, this is possible. You cannot just give away like their share. However, their share can be kept as a trust, which will be used for the benefit of the child.
Okay. Next question here is, when the property you own is given to your children, does the 500k threshold include the market value of the property when death happens, or the property value is excluded from the threshold?
No, the property value is considered, and obviously that is how you're going to be valuing the estate, and that is going to be on the date of the death of the deceased. So that's going to be the value, the market value at the time of the death.
Okay. I'm just trying to decipher the next question. Oh, it's by Brother Hisham again. This is going back to the child with learning difficulties. So he's asking a further question. Will it be the UK government who will take over the share of that child and spend it on the child, even if the sibling of the child are under 18 at the time of inheritance or parent's death?
Well, as I mentioned earlier, in your will, if all your other children are under 18, are minors, you can write in your will that this is how we draft our wills, is that my son is going to be the first question. Sorry, because it's got two questions. So first part is, the UK government will take over. No, as I mentioned earlier, in your will you can instruct to form a trust, and that trust is going to be controlled by the trustee appointed by you in your will. So you can appoint, you can direct to set up a trust after your death from the share of that child, and that's going to be dealt by the trustees, and also, and if the executors are also the trustees, so it's going to be the executors. Now, if all your children are minor at the time of the death of both parents, then obviously all your state, it's going, all the state which goes to the children, is going to be held in the trust until they reach the age of 18, and then each child is going to get their relative share, at the 18th birthday from that trust. Yes, if you do not leave a trust, if you do not leave a will, yes, in that situation, everything is going to be directed by the court. So everything. So if you don't have a will, yeah. So if you don't leave a will, then yes, then the court can decide, and the court will instruct to form a trust which will keep, your state on behalf of your children, and then it's going to go from there. So that was about, the UK government, and then about like in your will, you can make an instruction that my son A would be the trustee of my son B's trust, but if at the time of my death, or of both of our deaths, my son A is minor himself, then you can nominate a person A can be the trustee of the trust until my son A reaches the age of 18, or you can make it 21 or 25. You can actually define that age as well in there as well. So yes, you can, if you're making a will at a time when all your children are minor, you can actually leave an instruction that your children will take over, the trustees once they reach that age. I hope I'm able to explain it.
Thank you for that. Brother Isra would like to clarify a point you made on the pets.
Yeah, apologies. I'm conscious of time as well. Ali, just a question for you, and I know it might not be an easy question to answer, but in terms of from a tax planning perspective, if you were, and I'm sorry, Islamic legal law perspective, if you hypothetically had an estate worth £1 million, but you decided, 10 years before your death to gift assets, my question is as part of your Islamic inheritance, would it include the pets or not? Because that you've gifted in your lifetime as you choose, and it's totally different to what happens at your death. So I just want to clarify, if you gift assets through PETs, potentially exempt transfers, would that constitute as part of your Islamic inheritance, or is that treated separately? That was the first part. And the second part, I just wanted to make people aware. I've seen a hell of a lot of Islamic marriages where people are not actually legally registered under the UK law, and obviously that could have an effect in terms of UK inheritance tax law, where you don't actually have a UK legal marriage and only an Islamic marriage. So should everyone basically go and have UK legal marriages if they haven't already got one? Thank you.
Right. As I said, obviously I'm not Islamic law expert, but I believe, under whatever my studies are, I believe that any legacies you're making within your lifetime, they are not included in your inheritance. So your inheritance means any miras that you leave at the time of your death. So I don't think they would be considered towards, for example, if you are making any gifts during your lifetime to your spouse or to one of your child, or in my opinion, obviously you need to double check it with some Islamic scholar, it may not be may not conflict with everything that you're leaving, or may not be included in your anything that you've left in your will. Saying that, as we all know, that Islam always educators about adl, insaf, and equality. So I believe that any gifts a person is making, during his lifetime, would be would kind of consistent and equal, amongst his normal years. The second question that you asked, and I just forgot what did you ask? That was about the. Can you just repeat, please? Sorry.
Sorry. The question was, there's a hell of a lot of people that have Islamic marriages, but not actually UK legal marriages.
Yeah, got it. Yes. Yeah. So yes. Again, it is not. In terms of inheritance law, anybody who is your spouse, and it also includes any religious ceremonies, so it's civil ceremony or a religious ceremony, whether it's at church. Even if it is not registered at a UK registry, but it was registered, for example, if somebody got married in Pakistan or India, and they have that certificate, they are also legally their spouses. So it's not like everybody needs to get like re-register their marriages in the UK. So that's not like a mandatory thing. However, if it was just like a nikah at a mosque with no documentary evidence, I would definitely advise people to have some sort of documentary evidence or registration, whether it's registration at your local authorities like overseas, or registration with a Islamic center, because every jurisdiction is different. So it's hard to comment on it, like what evidence would be counted. However, they are equally acceptable and considered if you've got like an evidence for it.
Okay, there's one further question here. According to Islamic law, will the same laws of the will be applied automatically to pensions held, or they would need to be separately mentioned in the will? How the pension should be distributed? Let's assume you have mentioned in pensions that 100% goes to the spouse, but the will follows Islamic laws of inheritance. So I think the question is around how would you split the pension? Would it go automatically 100% to the wife, the spouse, or is there a different way to segment that?
Well, obviously, the way pensions are dealt in this country, obviously that's not according to the Islamic law. This is like according to the UK law and legislation, and your arrangements with the provider, and they goes straight away to the spouse or anybody you have nominated, because it is an income pension. Like if it's a pension fund which is released at the time of at the time of the death, in a lump sum amount, yes, it will just go to will be included in the deceased state. However, if it is like a regular income that that the spouse is going to be getting, it's really hard to put a number on it, because you don't know how long the surviving spouse is going to live. I can't obviously be very certain on the Islamic aspect of it, because my limitation, I'm not an Islamic scholar. However, I believe if it's a lump sum which is received at a time of death, that could be included. But if it is an income, an income arrangement that the surviving spouse is going to get, it cannot be included in the inheritance calculations and value of the state. In the UK, where if there is any income, which is to be received post the death by the spouse, it is not, we we do include them in your inheritance tax, but however, they do not get considered, because you don't know how long that that surviving spouse is going to survive post the death of the. It could be 1 year, it could be 50 years. You don't know. So it's a hard and tricky question, and but as I said, you can plan as much as you can, and things that you are sure about and you're certain about. And I think if the pension fund is an income-based fund that is to be received by the spouse, it will go to the spouse, and it's down to the surviving spouse if they believe that they want to share it amongst the other survivors or beneficiaries. That's down to their discretion. However, I don't think you can make like explicit wish on that, because it is going to be their money once you're gone.
Just a question from me. How long does it take to create a will?
Not very long, because it's a very pretty standard document. It's not a very lengthy document. It only includes, as I mentioned, it talks about who your executors would be, any guardians, your burial wishes, any legacies you want to leave. How it goes in most of the firms or most of the, so you can always get like off the shop will template from WH Smith or any other stationers, and you can just complete it and leave it. But again, executing, so that may just take you probably an hour or so. However, if you want to, the process where it gets a bit lengthy is, when you are you're, as I said, making plannings for your estate, and calculating and things like that. So that may take longer. It really depends on individual to individual matter, but usually the process is, if you instruct a practitioner, they will go through a questionnaire with you where they'll ask you all the questions, names and addresses and things like that, and names of your beneficiaries, executors. Once it's completed, they will draft a will. They will send you a draft copy. If you approve, you need to go and get it signed at the practitioner's office, or if you can arrange 2 witnesses in your household, or who are not the beneficiaries, you can get it executed and witnessed, in your own premises. So it can be done all remotely as well, because of using electronics. So it doesn't take very long time, but it really depends on what if you want to make any planning, that may take longer. Secondly, another point is, if you are nominating anybody as an executors or guardians for your children who are minor or with learning difficulties, probably taking their consents and things, it may also take some time. But in terms of the actual drafting and executing the bill, it's not a very long process.
And the cost?
Well, but as I said, obviously, you can, if you wish to just go and buy a template, and that may just cost you 70-80 pounds, at WH Smith, or even cheaper. I'm not really sure. Every practitioner have got their own prices, so I can't comment on that. What the firm that I work for, it's called SAB Solicitors. We charge 250 pounds plus VAT on wills. And then if a husband and wife are making wills together, which we call mirror will, mirror wills are like, because they've got same children, so what happens, and same spouses, so if their wishes are same, obviously they get like a kind of discount on it, but these are the kind of costs, which will include the initial consultation, drafting of your will, final will, execution, and witnesses. So once we've witnessed, you've executed the will and witnessed it, we keep a copy in our, on your file, so a sealed copy in your file, and we also give you a copy to take away, and then you can make copies and give it to your executors if you want to. There are other services available, not with us, but there's a service called Will Bank, which charge you probably 30-40 quid, to register with them, and you can upload your will, or you can provide information about your will to them. So whenever it's the time and your executors are not able to find your will, they will be able to find it on the wills register and will be able to retrieve it from there. So this is like an associated cost to it, but in most of the cases, it is the practitioner's costs are between 200 to 300 pounds.
Brilliant, thank you. I don't think there's any more questions. Okay, I think we'd probably look to closing the webinar. So really thank you very much to Ali Shah for your time and really giving us a comprehensive insight into the different frameworks and the rules that govern completing a valid will. And I suppose the key really is to maximize the benefits for the beneficiaries. So great insight into all of that, great questions and contribution from the listeners in. And just on a slightly different note, this webinar will actually be published on our website and the YouTube channel, along with all of our previous webinars. So everyone, just keep us in your prayers, and Jazakallah khair for logging in and joining us, and Assalamu alaikum.
Thank you.